We've had a slight delay, as you know, for unfortunate reasons, but thank you for coming to the 245 panel. This is an advanced panel on emerging issues and developments in asset recovery law. This is our third year in a row of doing this format, our sixth time, and the way we do this is we have a panel right before the break. This will take us up to the break. There'll be a short break, and then the second half of this panel will come back. I have the pleasure of co-chairing. My name is Ed Davis. I'm with Sequor Law here in Miami. To my left is my co-chair of these two panels, Steve Baker from Baker & Partners in Jersey. To my right is Tara Archer-Glasgow from Higgs Johnson in the Bahamas, and to her right is Jonathan Tickner from Peters & Peters in London, and to my extreme left is Craig Boneau. I want to pronounce that right. Did I get that right? Boneau, sorry. Boneau from Reid, Tsai in Austin, Texas. And this is intended to be a somewhat intermediate or advanced level. So if those of you that attended the last panel, which was more of a 101, this is intended to take us to the next level. And we're trying to focus on changes in the law that have occurred in the last 6 to 12 months, if we can, although we'll reach back periodically further. And we're looking at tactics, new tactics, and developments that are both positive for asset recovery and negative for asset recovery, so that we can think about and talk about strategies to get around some of those negative developments. It's intended to be an interactive panel, both amongst the panelists and amongst the audience. So we will welcome questions. We will not welcome speeches. We will not welcome people seeking free legal advice from the floor. You can do that later at the cocktail, but we will welcome questions and meaningful interventions. So if we can kick right off, our first issue that we're going to deal with. So we're going to break up this first panel into two pieces. The first piece will be dealing with claims issues, and the second piece will be dealing with discovery issues. Craig Boneau is going to start us off with an issue regarding pre-petition considerations that foreign IPs should make before seeking Chapter 15 recognition. Craig?
Thank you, Ed. So as most of you probably know, Chapter 15, just briefly, is a portion of the U.S. Bankruptcy Code that allows a foreign liquidator or insolvency practitioner to come to the U.S. and have their foreign insolvency recognized in U.S. courts, and then take advantage of some aspects of the Bankruptcy Code that have been incorporated through Chapter 15. It provides many, many benefits, and in most situations, it's the absolute right choice if an insolvency practitioner wants to come to the U.S. and take advantage of our laws. However, as a result of the Fairfield Century case that came out in late 2018, it was a Southern District of New York bankruptcy case. It turns out that some of the what I would consider disadvantages of the Bankruptcy Code are also incorporated into Chapter 15. And in particular, if what you're looking to do when you come to the U.S. is really seek to bring an avoidance claim related to redemptions out of a fund. So that's what was happening in Fairfield Century. Fairfield Century was a feeder fund in the Madoff Ponzi scheme, as I'm sure most of you know. The Fairfield Century liquidators got a 15, came to the U.S., and were seeking to avoid redemption payments that were made to investors in the lead up to the liquidation. What the court held is that a defense that is incorporated in the Bankruptcy Code called 546E was imported into Chapter 15 through a different statutory scheme, and it provided a defense to, or it provides a defense to fraudulent transfers, even if those fraudulent transfers arise under foreign law, which is what in Fairfield we had a BVI avoidance action, or a couple BVI avoidance actions, even if it arises under foreign law, and if it only includes foreign conduct. So there the transfers occurred out of a foreign bank account and a foreign entity, went to a foreign bank account, to another foreign individual or entity in the investors, and the court held that 546E nonetheless could apply. Now, 546E includes many things. There are a number of things that you sort of got to hit in order for 546E to provide a defense. One of them is the transaction that you seek to avoid has to be a settlement payment related to a security contract. So that's sort of a definitional term, a number of definitional terms, but it's effectively been interpreted very broadly to include things like redemption. So when an investor redeems out of a fund, that's going to fall within what 546E would cover. And then there are some other aspects about the types of entities that have to be on either side of it. That question actually hasn't been answered yet. In Fairfield, it's still being litigated. But critically, if there hadn't been a 15, all of the 546C issues wouldn't relate to these fraudulent transfers that are being brought, because the only reason that 546C is being brought here, is being advanced as a defense, is because of the 15 aspect. So the real short of it is unlike prior to Fairfield, where really most of the aspects of a Chapter 15 were all advantageous. Now, depending on what you want to do in your 15, if you really, the thrust of what you're trying to do is to seek avoidance under foreign law for redemptions of investors. If that's what you really want to do, you may not want to go the 15 route, because you may walk yourself into quite a formidable defense under 546C. I should also note that depending on what you're doing with your fraudulent transfer, whether it's an actual fraudulent transfer or a constructive fraudulent transfer, 546C applies differently. And there's a footnote in Fairfield that says that if it's an actual fraudulent transfer, just like in the bankruptcy context, it probably wouldn't apply. So if what you're bringing is really an actual fraudulent transfer under foreign law, then you may not be as much concerned about this. But if, like in Fairfield, what they have is a constructive fraudulent transfer seeking to recover redemptions back from investors, it would behoove you to consider whether 546C is going to apply to your claim before you just haul off and file a 15, because you may, in fact, walk yourself into quite a good defense.
And another pre-consideration you should be thinking about before you file a Chapter 15 is, should you be filing it at all? And up till now, there's been a lot of discussion and some suspicion that there was room out there for arguments that some claims could be brought, or at least defenses asserted, by a foreign representative without actually opening a Chapter 15. And now we have a case out of the Southern District of New York called the Ban Roe Corporation Case. And let me just give you 2 seconds of background. Ban Roe Corporation was a Canadian insolvency proceeding, and in that proceeding, it was widely publicized. There was a claims procedure, and a group of U.S. investors decided not to file claims in that Canadian bankruptcy. After there was a claims procedure, after there were adjudications with regard to claims being barred, there was a claim brought in the United States by several of the investors against the company, securities claims brought by several investors against the company. The company, through its foreign representative and the former CEO, who had been absolved or given a release as part and parcel of the Canadian bankruptcy, raised as a defense these Canadian defenses. The fact that there had been already discharges given and waiver by virtue of a failure to file claims. And the court never addresses Chapter 15 at all. It simply applies comity principles and says, you guys knew about it, you had a chance to file your claims, you decided not to file your claims, I'm going to dismiss this, I'm going to enforce under principles of comity the releases that were given in the foreign bankruptcy. Now, it is a rare case that we would probably ever advise anyone not to open the 15, because you have so many other powers that come with it. But here, there may be some factual scenarios that you need to open your minds to, where you would just proceed without opening the 15 and raise defenses in the proceeding. I can't tell you that you can take this case you shouldn't take this case too far, but it is a crack in the wall that you should think about as you decide whether to deploy a 15 or not. So that's one issue on a pre-petition claim or consideration that we wanted to raise. I want to turn now to Tara to talk about some developments in Bahamian clawback law.
Yeah, thank you, Ed. So the one way, of course, of recovering assets in the Bahamas is through insolvency, winding up companies. You can do it voluntarily in the Bahamas or involuntarily. And the Bahamian insolvency law permits a liquidator to basically claw back certain transactions made by an insolvent company within a specified period prior to the commencement of the liquidation. So if there was a transfer of assets made within 3 to 6 months of a company going into liquidation, then Bahamian insolvency laws allows the liquidator to make application to claw those funds back. And a recent case in the Bahamas discussing this issue is the AWH Fund Limited versus ZCM Asset Holding. It's a Bermuda company. It's a case that traveled its way through the Supreme Court to the Court of Appeal, and we're now waiting for a decision from the Privy Council on whether the clawback clause has extraterritorial effect. So therefore, in the AWH case, it was a mutual fund. It went into compulsory liquidation, and the liquidator, in collecting the assets globally, found out that the respondent company, the Bermuda company, had redeemed its shares in the value of some $13 million within 3 months of the company going into liquidation. And therefore, the liquidator properly brought an application to the court to seek a clawback application, wanting to go into Bermuda and to get those funds back. The liquidator also wanted to apply for an order that the directors of that company committed fraud and misfeasance by allowing a payout of $13 million to the Bermudian company just a few months before it went into liquidation. However, the appellant company, the liquidators, met a hitch in the legislation in the Bahamas because there's only certain circumstances where you could apply to serve an application outside of the jurisdiction. And the respondent company, the Bermuda company, argued that the liquidator could not seek leave to serve in Bermuda, and therefore he is prevented from attempting to recover that $13 million. The Supreme Court agreed with the Bermudian company and denied the liquidator leave to serve in Bermuda. However, on the Court of Appeal level, the Court of Appeal reversed the Supreme Court and said, no, the liquidators have an obligation to the court and to the company to recover all assets. The legislation has to be read collectively, and granted the liquidator leave to serve in Bermuda. However, before that happened, of course, the Bermudian company then applied to the Privy Council. So all the insolvency practitioners, many of them are in this room today actually from the Bahamas, are waiting for the Privy Council's decision, because if the Court of Appeal decision is overturned, then we're going to need to amend our legislation, because in effect you're going to be prevented from seeking to recover assets outside of the Bahamas, which is a little bit ridiculous because that was the purpose of the clawback clause.
Thank you. And just to add one other point that goes with, I guess, Craig's initial comment and mine is that, and really feathers into Tara's, is that insolvency, we're talking about insolvency, and some of you who aren't practitioners, who aren't lawyers, and who don't see this issue on a regular basis might wonder, why are they talking about bankruptcy or insolvency? Well, the reality is, and some of you who've been at this conference before have heard some of us say that we feel like insolvency is the nuclear weapon of asset recovery because it gives you so many powers. It has issues, as you've just heard from Craig, but it is a very powerful tool that we use. But we have other tools we use too, including injunctions, and in Latin countries, embargo preventivo. And Jonathan's going to walk us through a sort of new and interesting application of injunctions in the UK and possibly further in the Commonwealth countries, involving injunctions against persons unknown. So would you first set that up and then explain it?
Thank you.
Let me get a glass of water, so I'm not leaving the panel.
Well, I wanted to highlight a recent case which is linked generally to the emergence of tech advancements. I thought it was helpful. There was a quote in the Times last year where Times journalists said that there was a growing perception that AI will replace lawyers. So I kind of paused when I'd read that. But then thankfully he went on to say that this will not happen, at least not soon. Adopted correctly, it will empower lawyers to work more efficiently and effectively rather than making them obsolete. So we can sort of breathe a sigh of relief over all our kind of collective impending fate. What I wanted to discuss was a case of CMOC, Sales and Marketing Limited. The case itself, the underlying facts, aren't actually that interesting. It's a hacking of a UK subsidiary of a Chinese mining company by persons unknown. They'd infiltrated the email of a senior director, and they were able to send emails purporting to come from him, which enclosed payment instructions to relevant people at the Bank of China in London. So the Bank of China, they thought on the authority of their client, their customer, they made various payments. And the hackers mimicked the company's usual method for requesting the bank to make payments. So over the course of around 20 transactions, the withdrawals, the unauthorized withdrawals, were around about $10 million, and those funds were forwarded to other banks. All of that's straightforward. I think a lot of people here have seen that before, had clients who've sort of been the victims of that type of fraud. In this particular case, the CMOC were prepared to do something about it. So they didn't know who was responsible or where the money was. But what they were able to do was they were able to go to the English court and they got a worldwide freezing injunction and disclosure orders against 28 hackers' bank accounts, including against persons unknown and third-party banks, in circumstances where it wasn't known where the assets were, but it allowed disclosure orders to be made against overseas banks under kind of necessary and proper party rules. Now, this was the first kind of order, I think the first time that any such order was granted against anonymous perpetrators by the civil courts. And it applied to 35 international overseas banks in at least 19 jurisdictions into which the fraudsters had channeled the stolen money. And of course, the way that these frauds operate is as soon as the money hits one account, that account is emptied, it goes to another account, blah, 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 and the whole thing goes on. It's a sort of spider's web. So the number of banks involved increased to about 50. And in the course of obtaining these various freezing orders and disclosure orders, the court granted service on these persons unknowns through WhatsApp, Facebook Messenger, and email. And again, this was a very novel approach by the court to assist the victims of fraud. Obviously, WhatsApp has has a link. You can press info when you send a message, and you can show whether the recipients actually kind of read it or not. So that was taken into account in the evidence that was put before the court. I think there was one previous decision that had been made, which was sort of the precedent, which related to Harry Potter. I'm an English lawyer, so I'm going to mention Harry Potter. And there was a case in around 2003, well before the 6-month period that Ed's given me to talk about these things. But in that case, a Harry Potter manuscript for one of J.K. Rowling's books was stolen, and the court gave an injunction to restrain that book being offered to the media before publication. So again, in that case, they didn't actually know who the perpetrator was, but they were able to give the order. So this particular case, CMOC, was sort of piggybacking on that decision. I think I'm going to pause there, if that's all right, Ed. Yep.
Perfectly fine. So now we're going to move on to a different claim or cause of action involving fraudulent transfer, and Craig's going to walk us through the new developments with regard to the extraterritorial application of Section 548 and 550 of the Bankruptcy Code, the U.S. Bankruptcy Code, to be clear.
Right. So this case that Ed's referring to is the most recent Picard decision, in which Picard is the receiver in charge of the Madoff, the onshore U.S.-based Madoff funds. And through his receivership order, he's basically had all the powers that a bankruptcy trustee would have vis-a-vis fraudulent transfers. So he's brought fraudulent transfer claims. The interesting aspect of what he's done here is he's brought fraudulent transfer claims against recipients of transfers that the claim that the actual transfers themselves basically happened in 2 stages. So the first stage went from the onshore Madoff funds to the offshore feeder funds. So BVI, Fairfield, for example. And then the next step, which went from the feeder funds to the feeder funds investors, which really are related to the redemption payments that I talked about previously. And what Picard has said is that look, the initial transfer was fraudulent from the Madoff funds to the feeder funds, and then these subsequent transfers we can go after the investors as subsequent transferees, because that's an aspect of the Bankruptcy Code, U.S. Bankruptcy Code, allows you to go after whoever ultimately has the cash. You're not just limited to who the first person is that has it. The problem that he faced is that everything that happened in the second aspect of the transfer happened extraterritorially. So the offshore feeder funds were obviously offshore, not U.S. entities. The recipients were non-U.S. individuals or entities, and the bank accounts were all non-U.S. bank accounts. So there was a extraterritorial application defense asserted that said, look, the bankruptcy code is about what happens in the U.S. What you're talking about is all offshore stuff. And so therefore, you don't have the power under the bankruptcy code to go get those funds from these non-U.S. entities. The district court in New York agreed with that view of the world and said, that's right, you can't go after these funds. The Second Circuit reversed and said, you've looked at it entirely wrong. So the district court based its opinion largely on what was happening in the second transaction, and that all of that was non-domestic activity. What the Second Circuit said is, well, you're really effectively putting the cart before the horse, because what really matters here, the transfer that was truly fraudulent that you're asserting Picard as the receiver is the first transfer, the transfer that goes from the U.S. entity out of a U.S. bank account to wherever it goes. And under Section 548, which is the section of the Bankruptcy Code that describes what a fraudulent transfer is and what you have to establish a fraudulent transfer, the conduct that the code really cares about is the conduct of the entity making the transfer. So the debtor in this case, or the Madoff funds in this case. It doesn't really care so much about what the ultimate transferee did or didn't do or where they were or any of that. So the focus that the district court had on where that entity was and what was happening on that second transaction was misplaced, because what the court really should have looked at is the first transaction. And the Second Circuit said that really has a domestic focus, and as a result, we don't really have an extraterritorial problem here. The court also recognized, and I think ultimately the reason the court came to its conclusion is that if the district court's view of the world was right, and because the second transaction occurred between two non-U.S. entities, then there would be a loophole created in the bankruptcy code which couldn't have been intended there, whereby any fraudster that wanted to protect a fraudulent transfer, all they would have to do is transfer it to a non-U.S. entity and have that entity transfer it to another non-U.S. entity, and then it would be completely protected regardless of how fraudulent it was. And the Second Circuit basically wasn't willing to allow that loophole to occur in the bankruptcy code. So although the court goes to a very detailed analysis on the statutory reasons why it came to its conclusion, it also notes that, and that ultimately I think is probably the reason why the court came out the way it did. The court also notes, for sort of our purposes here, that its decision creates a tension, because, and it's a real tension in that case, and it could certainly be a tension in others, where you will have a U.S. trustee going after a transfer that flowed through an offshore fund in this case that could itself be in liquidation, have its own liquidators that are going after the same defendants for the same transactions. So here we have Fairfield that I spoke about earlier that's attempting to go after its investors for redemptions, and we have Picard going after the same investors for the same transactions. And the Second Circuit recognized that that was a tension, decided that it didn't rise to the level of comedy concerns that would prevent the U.S. trustee from being able to go after it anyway, and didn't really give a solution to the problem, but did effectively note that whoever wins the race to get the money or get whatever sort of settlement is going to occur is probably going to be the winner. Which means that if you find yourself in a situation where you may be in a competition with a U.S.-based trustee, you probably want to get to a resolution as quickly as you can so that you don't face a defense that says, look, you may or may not be, you may be right that that what you have is an avoidable transaction, but that exact transaction has already been avoided and paid for somewhere else, and so I don't have to pay twice. The other alternative obviously would be for the offshore liquidator to work with the onshore trustee to come to some sort of agreement about how they're going to split up this avoidance, depending on how well those two groups of folks are working with each other. That may or may not be a possible solution, but it certainly is one way to solve this problem. But it's certainly a problem that you need to be aware of, because now the Second Circuit has made it pretty clear that U.S. trustees can definitely go after redeeming investors in offshore funds, regardless of whether there's an offshore liquidation ongoing.
Craig, that's the power to do it. Let's talk about how it would be done. To the extent that they're chasing these, the second transaction, the transferee, if that transferee ultimately is back in the United States, we obviously can see how that's done. Assume that that person is offshore. Would the expectation be that this liquidator or this trustee would have to then seek recognition offshore and then go after those funds through that means? And would that holding, would that be something that could be exported along with it? I mean, do you think the foreign court would agree that power can be used to gather those funds in a foreign jurisdiction?
So in the first instance, the there's going to have to be some sort of personal jurisdiction over whoever the recipient is. So whether that investor, whether or not they're an offshore investor, they're located in wherever they're located, they're not domestic to the U.S. If there's no personal jurisdiction over them in the U.S., then this is likely not going to play out where the trustee is going to be able to get a judgment against them. However, if they have personal jurisdiction over them, but there's no assets here, or the big asset pool is in some offshore location, like where the transfer was sitting, then that's right. So the judgment may be a U.S. judgment, but of course, to execute on that judgment, you're going to have to go to the jurisdiction where the actual assets exist, and then depending on where that location is and what their view of the world and on how broad they think the U.S. should be able to apply its law, it may or may not be something that ultimately can be recovered, as it might be more likely to be recovered by the underlying liquidator who's going after it.
Gonzalo, did you want to add anything on that with regard to the sense? Why you?
Well, no, I mean, one of the interesting points on enforceability.
Let me bring a microphone down.
Is you really do have to look at the states where the subsequent transfer is located. There's a tendency to assume, if you haven't done these things before, there's a tendency to assume that, all right, I have personal jurisdiction over the defendant. I've dotted all the I's and crossed all the T's to enforce my judgment in the United States from state to state, et cetera. And then you go to another jurisdiction and you find out that default judgments are not enforceable. And the big problem that you have, at least that we had, the difficulty we've had in the Madoff case, is that most of the jurisdictions, or a significant number of the jurisdictions in which the subsequent transferees are located, follow what's called the dicey rule. And a line of cases that began with a case called Cambridge Gas and ended with a case called Rubin v. Eurofinance. The ultimate upshot of which is you're not going to be able to enforce that judgment unless the defendant was in the jurisdiction at the time that the action was commenced in the U.S., or if they substantively participated in the jurisdiction, or if they agreed by contract. We litigated every single one of these issues. We got all the way up to the Privy Council on the issue of whether an arbitration clause in the investment agreement constituted agreement by contract. And we settled right before that was adjudicated, but the Privy Council actually issued a judgment on it anyway. Fortunately for us, we settled right before the judgment because we got paid. The judgment actually went against us on that. So it is something you really do have to think about ahead of time. The removal of the prohibition on extraterritoriality, by the way, still doesn't solve that problem for you.
Anytime you get a judgment, whenever you're onshore, and onshore is wherever you're standing, right? Because onshore could just as easily be you're in the BVI coming to the United States. You have to get advice from folks in the jurisdiction in which you seek to enforce before you do that, because it's amazing how many times, and a lot of us have learned along the way by stubbing our toe, that when you get there with that judgment, the answer is not a happy answer. Any questions on this part of our panel? We finished the claims part. We're going to move on to discovery issues. Before we do, any questions?
So you talked a lot about the developments and basically creating competition between American trustees and foreign liquidators. This is creating a race to the courthouse, which is exactly what the bankruptcy system is designed to prevent. Do you see future court developments restraining that, or do you think this is just going to have to emerge out of kind of an organic agreement between liquidators and American trustees?
So it's a fair point, and the problem really, and the Picard case sort of outlines, the Second Circuit talks about it, is that it wasn't as though there was an offshore Madoff liquidation and an onshore Madoff liquidation, in which case you have parallel, same estates in parallel situations, in which case you generally are not going to, you would defer to one or the other, you wouldn't allow both of them to go forward. Here you have different estates, right, with at least partially different constituencies under different law with different requirements. And so it's harder to find a way to choose one over the other because it's really somewhat unfair to do so. So I really don't know the answer to your question. It's a great question. But I don't know how you're going to be able to pick one over the other.
Well, let's stay tuned for the second half after the break, because that half of the panel is going to deal with some of these conflict issues, both between rival liquidators, liquidators, receivers, and then liquidators and government agencies that are seeking to forfeit the very same assets that estates are seeking to bring in to pay victims. So let's move on to the discovery piece, and we're going to start with Jonathan. The first issue we're going to try to tackle is developments in law regarding the use of illegally obtained data and information from investigators. This I will ask Jonathan to point out, based on his vast experience, the differences he's seen between sort of applying that in a U.S. court and a UK court.
Okay, well, I'm not really qualified to comment on the US court, so I'll let others do that. I can speculate, perhaps. I mean, this is, I think, a very interesting topic for all sorts of reasons. It sort of fruits from the poison tree. So, if and when illegally obtained evidence can be, can it be deployed in civil litigation in England? I'm not talking about criminal cases here. I'm talking about civil cases. I mean, the starting point is that in English proceedings, there's no explicit rule of law that requires automatic exclusion of evidence from the court purely because it's been obtained illegally, or it's been obtained improperly. So, I mean, that's an interesting starting point. And in fact, I think in English civil cases, judges are more inclined to admit that type of evidence if they deem it relevant, because they then are given sort of all the cards are on the table. They can see exactly how the narrative plays out, and they can then decide, what weight to afford that type of litigation, notwithstanding the fact that it's been illicitly obtained. I think that's the starting point. I think what's interesting is that fraud litigation, particularly, is sort of high-stakes litigation, isn't it? It's sort of die-in-the-ditch cases. Temperatures run very high. Clients are often motivated by all sorts of issues to get results, and the people on various teams can be, whether it's the claimant or the defendants, can be motivated for those purposes. And there are obviously professional conduct issues at play here, because if the starting point is that this material can be disclosed and can be relied on and used, why or not we all sort of should be breaching the law in terms of for our own clients' interests. I think that there are a few cases which I think are interesting. They're not necessarily. Well, the first one is not necessarily in the fraud arena, but it's an interesting case where someone was working for a university in England and claimed disability in her hand following an accident at work. An inquiry agent, instructed by the defendant's insurers, by the university's insurers, obtained access to her home by deception, posing as a market researcher, and filmed the claimant using a hidden camera. And that film footage showed that the claimant had free use of her hand while she was at home. But in that, notwithstanding that the inquiry agent had clearly committed trespass, gone into the home uninvited, she argued that it was a breach of her human rights under Article 8 and that the evidence should be excluded. And the court disagreed in that case, concluded the evidence should be admitted as it would be artificial and undesirable for evidence that was relevant not to be before the trial judge. A more relevant case is the Inman and Chengwes case, and in that case, again, the court reiterated that illegally obtained evidence could be used in civil proceedings. In that case, there was a divorce case, and these are very well kind of Inman and Chengwes are kind of quite well known in the UK as sort of well-known financial people, sort of wealthy. Ex-husband shared offices and a computer system in London with his brothers-in-law, with the Chengwes brothers. And when he petitioned for a divorce, he was evicted from the offices by his brothers-in-law, following which one of the brothers-in-laws, who was obviously the brother of his sister who was married, thought that he would conceal his assets for the purposes of the divorce, and that he had all his computer servers copied, information documents, including password-protected material, was all printed off, and it was all passed to the lawyers acting for the sister in the divorce proceedings. That went to the Court of Appeal, and the Court of Appeal said, oh, you know what, we don't really like that kind of behaviour. It's, you know, we shouldn't really be encouraging parties to take the law into their own hands, illegally helping themselves to information or documents. However, they also reiterated that that kind of evidence can still be used in court, acknowledging the fact that common law does not usually concern itself with how evidence is obtained when considering admissibility. So in that case, you know, the question is whether the court should exercise discretion to exclude or not admissible evidence. And I think that it's interesting that obviously in the UK it's an adversarial system, so lawyers can sort of can pursue their client's case fearlessly and rest on the premise that you know, both sides are going to sort of vigorously dispute their client's case, and somehow you'll get to the truth. I think that the difficulty is that lawyers acting for claimants and parties where illegally obtained information is obtained, they obviously need to ensure that the court is told where this information has come from. So they have to go to court with clean hands, particularly if they're making a kind of application for worldwide freezing relief. So, I mean, the short point is if you go with clean hands and you sort of kneel before the court and you say, we've got this information, we shouldn't have it, but we've got it, and this is where it's come from, and you give full and frank disclosure, it's then in the court's hands whether or not they allow admissibility, but you're not, if you go with clean hands, effectively you won't necessarily be penalised on costs. I mean, that doesn't detract from the fact that criminal offences are being committed here and the police can walk in and still prosecute.
Yeah, we could literally do a whole panel just on this one topic. I mean, every lawyer in this room has probably had at least one circumstance where a client has come to them and said, I've got this stuff and I want to show it to you. And you're like, well, where did you get it from? And then you get a story that starts making you queasy. And so we've all been there. And how do you deal with it? In the U.S., it is very different. Courts, both our federal courts and our state courts can and do at times suppress information that is taken improperly. And that's usually the least of your problems, because if you were involved as a lawyer, you might win the case, but you'll lose your license to practice law. So it is a very, very significant issue that when there is illegally obtained evidence, and it's not one that we can tease out to its, because we've got other topics to cover today, but it's one we wanted to point out that there's a difference in where you are in the world as to how this issue is dealt with by the courts, and B, that at least in the UK, and I assume the UK influenced courts, and Tara, you might comment on this, that it's a similar rule, say, for example, in the Bahamas and other Commonwealth jurisdictions.
It's a similar rule, but I don't think we're that advanced yet. Certainly, when you provide evidence to the court in the Bahamas, you have to state where you got it from and why you have reason to believe that the information is true and correct. So you couldn't say in an affidavit you hired an investigator to find out what accounts the defendant banks has money in. And so I don't think we're that advanced, but if you do have information that could assist you in tracing, then there are mechanisms in our rules of court that a litigant could follow to help get to the same end by lawful means.
So I want to bring another...
Could I just add one point? Sorry, Ed. Sure. Ed, it's me. I'm over here. Could I just add one point?
Right up.
If you have got an errant investigator who does give you this information, I'm not saying that there are any errant investigators in the room, but it would amount to a waiver of privilege. So whilst the evidence is admissible, the communications giving rise to how that information was obtained and how the information and material came into the hands of the claimant or the party can be ordered by the court to be disclosed. I think it's just an important point to make.
Absolutely. Thank you for making it. Let's talk about 1782. 28 U.S.C. Section 1782. For most of you who were in the last panel and been around this know this is a very powerful tool codified in Title 28 of the U.S. Code that allows foreign litigants to obtain evidence in the United States for use in proceedings in foreign jurisdictions that are either already ongoing or that are reasonably contemplated. And I want to, and one of the requirements is that the evidence has to be found from a target who resides in the district in which you are seeking it, or the evidence is found in the district in which you are seeking it. And there is, since our last meeting in London, there have been a line of cases that have come out of the Southern District of New York, which are very disturbing. from those of us who use 1782. Very scary, frankly. In the case called In Re Ruiz, Judge Ramos decided that he needed to apply the Daimler and Gucci requirements, which are U.S. cases that deal with personal jurisdiction, and find that there had to be general jurisdiction over the discovery targets in the context of a 1782 application when dealing with the reside or be found prong under 1782. And he found that for the purposes of a corporation, that means where the company is incorporated. So imagine you have a bank that's incorporated in Nevada, and they have a branch in New York. That's not a huge problem for the use of 1782 because you can go to Nevada and refile your 1782 there. But where this came up and where it comes up routinely is when you have an entity that is offshore but has an ongoing and continuous and systemic operation in, say, Miami, and they are doing business in Miami for all purposes, other purposes, but they're headquartered, they're not incorporated in Florida. And under the Ruiz analysis, you would not be able to bring that 1782 in Miami against that entity. So, but I will tell you, other judges in the Southern District of New York don't agree. So a month later, or 2 months later, in a case, Judge Broderick found that the discovery target only needed to be found in New York without regard to general jurisdiction. And then a third judge, Judge Polk, required supplemental briefings just recently, a month and a half ago, on the issue of whether the discovery targets are found within the Southern District of New York, and Judge Polk is going to make that determination. So you see this line developing, which is quite disturbing, that could seriously limit how the scope and reach of 1782 were this to be codified eventually through some sort of Second Circuit ruling or spread to other district courts. I can tell you in the district courts where we've obtained them in Kansas and in Texas and in California and Michigan and Florida and Connecticut, this has not come up at all. It's always been about whether the target or the evidence is in the jurisdiction. So this is I think something to keep an eye on. We'll report back on it 6 months from now, but not a very promising development if you ask me. We're now going to turn to you, Tara, and talk about the ability of other countries to use letters of request to obtain private banking information to trace funds in the Bahamas, and we'll extrapolate from that to the extent we can to other jurisdictions.
Right, thank you, Ed. So we discussed, we're trying to find the assets, tracing. We discussed insolvency, winding up the companies. And so another avenue in law that a lot of claimants use is the letters of request. And the Court of Appeal in the Bahamas handed down a decision in January of this year dealing with a letter of request and stating exactly what has to be in it if a litigant wants to get a successful order. So the case involved the Carwash Scandal that some of you may know about. The federal prosecutor in Brazil was investigating one of the largest corruption schemes ever discovered in Brazilian history. High-level employees within the state company Petrobras, which many of you may know is an oil and gas and energy company in Brazil, was receiving bribes in order to hand out private contracts, and over $1 billion got stolen from the Brazilian government, and the Brazilian government basically went on a worldwide tracing exercise to try to recover some of the money. No surprise, some of the money was found in Switzerland. It's alleged that some of the money was found in the Bahamas as well. And so what the Brazilian government did is issued letters of request to our court, but it was very wide. So it just asked to get accounting information about 10 persons, and only one of the persons were the actual defendant, Paulo Roberto Costa. The other persons allegedly got mixed up in the wrongdoing innocently, and the only connection that the other persons had to the fraud was that they transferred money into an account from the Bahamas to Switzerland, and that account in Switzerland, the target of the investigation confessed that all the money in that account was a result of bribes stemming from the Carwash Scandal. And from that general allegation, anybody who transferred money to those accounts was subject to the letters of request, where they had to give their identity, the source of the funds, and of course, persons resisted that. An application was made to the Bahamian court to set aside that letter of request because it was too broad, it was a fishing expedition, there was no connecting factors to the persons that the Brazilian authorities wanted information about. The Supreme Court didn't set aside the letter of request, but they used what we call a blue pencil, so they narrowed it. So instead of asking for the identity of the account holders to be disclosed, they said just give the amount, give the source of the income, and produce all the documents in the file. Now, of course, if they produce all the documents in the file, the identification documents would be produced. And that was a no-no, but the Supreme Court did not set it aside. The Court of Appeal, however, in its ruling issued in January, did set it aside. They said the letters of request, whilst in the interest of comedy and combating fraud worldwide, you still have to actually prove your case. And whilst the courts wanted to help, they said unless you could find some more connecting factors to the individual, they would not breach their constitutional right to confidentiality, and so they set aside the letters of request. So we were discussing that when we were preparing for this panel, and you know, a lot of times we say you should seek legal advice in the jurisdiction where you want to enforce the letters of request to find out what is necessary and what has to be proven, so when you draft it, it can be specific and it can be upheld. I don't know, Jonathan, you would say.
I want to add one thing quickly, and that is that I want to just reinforce that point. So I don't know how many of you do corruption work where you represent governments or state-owned enterprises. I know some of you do from personal experience. And how many times have you seen where the government has attempted to obtain information through this letter of request, which sometimes are referred to as mutual legal assistance requests, and they're horribly drafted, and they don't tick all the boxes. They don't even comply with the treaty which is between the two governments. And I know, Jack, when you were in government, dealt with this on a regular basis. And I asked someone once, why don't you hire outside counsel in that country to give you advice on how to do this? And they said, well, then we would look stupid. If we would look like we don't know what we're doing. And I said, well, does losing the MLAT make you look less stupid than asking for help before to make sure it's successful? And it's silly, but it is a bias that many government actors bring to the table, especially from countries where they may have concerns about the perception of them, and they didn't want to be perceived as looking like they didn't know their job. So, Jonathan, you wanted to add something to that?
Well, really it was the point that I think we discussed earlier was actually in the context of criminal proceedings. And I know that for extradition requests, I'm not an extradition lawyer, but certainly having spoken to some of my colleagues in my firm, we certainly sometimes get consulted by overseas states because they find that extradition requests are often turned down by the English Crown Prosecution Service because they are so poorly drafted. And, again, it goes back to the point that Ed and Tara have made, which is obviously if they actually consulted local lawyers who know what they're doing, they may find actually it's a more productive and actually relatively could be a relatively straightforward process. Or more
Same lesson with regard to private request under the Hague or any other types of requests. You still should be getting local assistance to make sure that it's drafted in a way that is friendly to the eye of the person receiving it.
Ed, can I,
Sure.
I hope, usefully add an anecdote? I spent 2 years, many years ago now, working in the Attorney General of Jersey's chambers. Old Jersey, just to remind everybody, not New Jersey. And an MLAT, letter of request, came in from a country which I shall not name, but in the former Soviet Union. And it was unintelligible. It was absolutely unintelligible. It must have been, it was probably before Google, but it must have been Google translated. It was so bad. And a young lawyer had to fill in a box which said, does this letter of request fulfill the requirements of the investigation of fraud law? And he was struggling with it because it was unintelligible. So he explained to him that being unintelligible he couldn't tick the box. So he got sent back with, this is unintelligible, please could you translate it? Nothing happened, and a new law came in. There'd been an investigation of fraud law, and they introduced in Jersey in all crimes international corporation law, so it didn't have to be fraud anymore. And the young trainee lawyer brought it back and said, is it all right now? So it was still unintelligible, and it still failed the test, and he's now a physiotherapist.
Tara, then that takes us right into your other topic under discovery, which was what are some of the legal avenues available to claimants to obtain private asset information? Again, outside now the criminal context, outside the government to government or G to G world, what are typically people using, and any developments in that in the Bahamas?
Right, so another tool that we see often being utilized in the Bahamas is the Norwich Pharmacal type application. That's when basically an innocent third party gets involved in a wrongdoing innocently. So they're not involved, but a claimant needs discovery from that innocent third party in order to facilitate their claim. So a lot of times you would see banks getting these type of orders made against them, where they may be holding accounts for a person being sued. I just did a recent case with Ed, actually, where it was a divorce case, husband and wife, and the wife was trying to trace the assets of the husband, which, surprise, was in the Bahamas, being held by a registered company there. And so the wife instructed us to get a Norwich Pharmacal order against the institution that was holding the documents and the assets for the husband. And the courts readily grant those type of orders once you're able to show that you have a strong reason to believe that the documents being held will assist in the case. And it helps asset tracing, and it stops fraud. The courts will grant that type of order. And in this particular case that I did with Ed, it was interesting because normally the cause of action has to be taking place in the Bahamas when you're seeking that type of third-party discovery. But in this case, the cause of action was actually outside of the jurisdiction, but the wife was still able, we were still able to get an ex parte order where the judge ordered that the third party innocent person produce all the bank documents, all the assets, anything, and send it out of the jurisdiction for utilization in the foreign proceedings. And you commonly see that being done.
What happens, and I'll open this up to both of you, Jonathan, and you, Tara, and anyone in the audience, when you get discovery from an innocent third party, a putative innocent third party, and it turns out they're not innocent. The information you obtained is not innocent, because in the 1782 context, which is our closest analogy, John Moscow and I were talking earlier, generally speaking, when an action is on foot, when it's actually running in a foreign country, you cannot get discovery from that party with a 1782. When it's reasonably contemplated claim, you can. You can have huge fights about whether someone's an affiliate and an actual party, but there is a body of law now developing that when you discover information that's useful against the party, you can use it under Glock v. Glock. Do you have a similar development when all of a sudden now you realize bank may have been involved and you now have the smoking gun in your hand?
Yes. I mean, you would, in those circumstances, obviously, when you make your application for a Norwich Pharmacal order, you don't have, you're going to the court saying you need disclosure from a bank on the basis that the bank has been innocently involved. If you're saying that there are documents that then arise, you can go back to the court to seek to get permission to use those documents if you're going to then bring the bank in. Yes. I mean, I'm sure the bank would try to put forward a defense that those, they were incriminating themselves and they were compelled to give the documents pursuant to a court order, and therefore it should be excluded. That's an interesting point that I'm not familiar with any recent decisions in the Bahamas where it was actually challenged, but it would be interesting. I'm sure the bank would oppose any application to bring a countersuit against them.
Yeah, just to pick up on that, we've fairly regularly done that. Serve a Norwich Pharmacal disclosure order on a bank or trust company. You read the papers, and lo and behold, the bank or trust company was involved in it, and we sue them for dishonest assistance or knowing receipt, often, of the complicity in the conspiracy.
Do you need to get permission to use that information? Do you have to go back and get that?
That's a really good. It's a really good question. I'm pretty sure not, actually, because they're disclosed for use in potential civil proceedings. I can see an argument that you would, but I don't think that we have in the cases that we've done it. Nobody's taken the point.
I know in the Bahamas you can't use documents provided in one action in another action without the leave of the court. I imagine that's similar to you too, Jonathan.
But I think it's an administrative issue. I don't think there'll be any issue with it in terms of whether the court granting it.
Our law is the same. I can't recall whether we've ever ticked that box, but there can't really be any issue that you could.
All All right, let's move on then to, anyone want to add to that or comment on that in the audience? Okay, then,
Can I, sorry, in terms of Norwich Pharmaceutical, can I just
Sure.
talk? There are two conflicting High Court decisions in England about whether or not a Norwich Pharmaceutical order can be obtained in support of overseas foreign civil proceedings, which is problematic to say the least, and probably needs clarification from the Court of Appeal. Those two court cases appear to draw a line between proceedings which are up and running in the overseas jurisdictions and those which are contemplated. And there is the latest decision, which was a couple of years ago in Ramalos Trading, where Mr. Justice Flo sought to say basically that the party was not entitled to the Norwich Pharmaceutical in support of overseas proceedings because they should be using the statutory route of letters of request. And it is problematic, and I've sort of had an approach recently where you know, if the overseas proceedings are not up and running, but actually what you're doing is you're seeking disclosure and to decide you may even start proceedings in England, then I think you can sort of play a more deft hand with the court in terms of getting that disclosure. But if you've already started your proceedings in the overseas jurisdiction, there may well be an issue there as to whether the English court would allow the Norwich Pharmaceutical.
same thing under 1782. It goes to who you can get it from, not whether you can get a 1782, but if you're seeking to do against a party in the United States, what you can't do in the foreign jurisdiction, and it's a party, then that's one of the factors. So let's move on to a new topic. The issue of the GDPR, which the General Data Protection Regulation in Europe, which I guess may or may not apply to you guys in the UK soon, not really sure. We'll talk about that in a bit. But the issue is now we see this sort of percolating into US cases where defendants have discovery requests served on them, and they're saying, sorry, Your Honor, I can't produce that information in the United States because it will implicate me and it will put me in jeopardy under the GDPR in the European Union. So it is an open issue, and we've now have two cases that have looked, very recently looked at this issue in December of last year and February of this year. One is out of the Southern District of New York, and in that particular case, and I'm not going to go into too much detail because we don't have a lot of time, the court ultimately made a practical determination as to how to deal with it and said, look, I'm going to allow it. I'm going to allow the discovery. I think it's narrowly tailored or tailored enough that I'm going to allow it, but I'm going to require that, number one, you plaintiff or you, the person seeking the discovery, and this was under 1782, pay all costs associated with copies and compliance with the GDPR. And that's italicized in the case. And the petitioner would have to indemnify the subpoena target against any breach resulting from the GDPR protected documents. So that's a pretty, what does that mean? Anytime a lawyer has to tell a client, give an indemnification, what does it mean? How wide is it? How deep is it? How long does it last? And what are the type of damages that you would be indemnifying against? So I don't know actually if they ultimately went through with the discovery, because this just happened a few months ago, but it seems to me that would chill the ability to use 1782. Now, and it's not like we don't have past experience with this issue, because we had blocking statutes in many countries, and most of our courts came to the conclusion that, look, we're not going to allow someone to enact a statute that then prevents our courts from properly adjudicating our cases, so that's your problem. Too bad, so sad, go get the documents and turn them over, or you'll be in contempt of court. And then we had another case that dealt with a similar issue just in February. It is now April still, so I got to get this right. Time is flying, and I'm going to butcher the name, but it's Hansaitisch Investment GmbH, and it's in New York. And in that particular case, the court and I was wrong. The first case I told you about was in California. This case is the New York case, and the court ultimately concluded that the importance of, you have to look at all of the factors with regard to whether it's going to enforce the GDPR. and ultimately said, we're just going to look at standard factors, the importance of the documents or other information requested to the litigation, the degree of specificity of the request, whether the information originated in the United States, the availability of alternative means of securing the information, and the extent to which noncompliance would undermine important interests of the United States. So that are the types of factors, those are the types of factors that you're going to have to satisfy the court in order for the court to override these GDPR issues. So I want to open it up to the audience on that point, and also to you, Jonathan, particularly you, or Stephen, who deal with this issue, and comment on whether or not you're seeing this, you've been consulted on this issue at all.
I'm happy. I mean, not well. The starting point, I think, is that data protection has a crime exception. So a party that has documents, an employer that has, email accounts and documents. The crime, on advice, and we often have to deal with this in the context of investigations. They are able to review email accounts on the basis that they've got reasonable grounds for believing that a crime has been perpetrated, and equally in terms of delivery up of documents and disclosure, no party to litigation can cite data protection as a reason not to provide disclosure on the basis that you can have a court order which tells the party they must, and that court order is going to override any data protection obligations that they might have to their, to employees or third parties.
Yeah, Ed, we haven't come across GDPR as a particular problem as yet. I think it's because, for the reasons that Jonathan says, that a criminal exception, also if you've got a court order to do it, then you've got a court order to do it. What we have got ongoing at the moment, which I think is going to be the first time that this issue is dealt with in a Jersey court, is this. And it's a branch of a bank in the Middle East. The branch is in Jersey, the headquarters is in the Middle East. We need information which the Jersey branch we think can get hold of, but on traditional analysis would be in the Middle East. So we're asking for Norwich Pharmacal relief, disclosure of material to seek to enforce a judgment. And we think that the Jersey court will order disclosure of this material if the Jersey bank can get hold of it. But interestingly, we reached that conclusion really on the basis that you highlighted that your courts looked at the blocking statutes, namely if we can show that we couldn't really get it by alternative means, the court will say, well, if you want to do business in Jersey, then you abide by Jersey law. I think it's an American judgment we're trying to enforce. They'll say we've got a request from a friendly jurisdiction to enforce one of its judgments. That judgment's been evaded. There's some information in this Middle Eastern bank which we can get, and we'll give it to you. Now, I might be here next year telling you we lost, hands down, or we could be on the way to the Privy Council, depending on how the bank approaches it, but we're quite confident on it.
It's a significant issue, and I think more than likely it's just an American judge being led about by someone who's not being completely full and frank about this. And so the benefit of conferences like this is that we can talk about the antidote, and the antidote is really that we just need to make it very clear to the court that there's a fraud or a crime exception. Now, I have a question. Is the fraud or crime exception, is it just crime, or is it fraud? Crime fraud, and does it rise to the same level as, say, avoiding the attorney-client privilege, or is it something lower than that? Anyone? If that's been developed yet in your law?
I don't know the answer off the top of my head.
I mean, I would imagine it can't be as high as the attorney-client privilege, the burden you have to overcome, but it would be worth, if anyone in the audience know if using or avoiding getting around the GDPR restrictions using the crime fraud exception, and I'm now grafting the word fraud on there just through I'm not sure that the word fraud should be used there, but would the level of proof would be at the level of avoiding, say, an attorney-client privilege communication? Anyone know? No one? All right. Well, then we'll find that out before the next conference and come back to you on that. Our last point, we're actually almost on schedule, notwithstanding that we started 15, 20 minutes late, is Jonathan. There was our last topic we really wanted to talk about was the privilege against self-incrimination in civil proceedings. And this was in the context of asset disclosure under the terms of a freezing injunction. Jonathan, would you set this issue up for us?
Yes, of course. So the rule in England, the starting point is that the privilege against what we're talking about here is where a respondent to a freezing injunction or disclosure order, where there is a penal notice attached, so the defendant has to respond, failing which they'll be exposed to a penalty which might include imprisonment or a fine. They have to respond, and that might include disclosure of their assets, disclosure of the whereabouts of documents, information, and so on. And if they don't respond, that they will be they could be imprisoned. So under that sort of threat, can the respondent say, well, if I disclose this information to the applicants, I am going to be incriminating myself in relation to a criminal criminal process, criminal prosecution. And that privilege has been around forever, but it is, over the last 30 years, been narrowed and narrowed and narrowed and narrowed to the point where it doesn't really exist. And the Fraud Act in 2000, the Fraud Act in, I think it was, I can't remember the statute, 2006, basically said, well, the English criminal law is such that a criminal judge can exclude all this evidence from a jury in terms of context of criminal proceedings. So you don't need to worry about exposing yourself to a risk. That's the sort of starting point. But I was kind of interested in, because obviously we're an international conference here, is the extent to which a respondent can say, well, I don't have to disclose this because it might tend to incriminate me in the context of overseas criminal proceedings. Forget about domestic criminal proceedings, overseas criminal proceedings. The Fraud Act wouldn't apply to that. So actually, there may be a discretion the judge would have to allow that privilege to be affected. But actually, a couple of recent cases, one for this year, has put pay to that as well. Because what the judges now say is, well, the privilege may not automatically apply, and in certain situations, what the court can do is it can create an additional layer of protection for the respondent by ensuring there is a confidentiality club. And that confidentiality club means that only the lawyers acting for the claimant can see the information, and then it will be protected. And that this is an immediate answer to the risk. And in fact, one case which my partner was dealing with, Keith, who's in the room, was this year, where effectively that confidentiality club was put in place, and so the privilege didn't apply, and the person was ordered to give the disclosure.
In the United States, in a civil case, you can take the Fifth Amendment, but you're allowed to draw a negative inference from it based upon a concern. It has to be a reasonable basis of criminal jeopardy. We now have a case in which we did 1782, which Christina's working on, where the other side took, or the deponents sought to assert their rights under the Trinidad Constitution, and said that they felt that they were under jeopardy of criminal prosecution there. And we said, well, that's nice, but there's no real case law that allows you to do that. There's one case out of the Second Circuit where an Argentine person was able to assert rights under the Argentine Constitution. But this is going up. It's going up on appeal, so we'll let you know next time, hopefully, whether we win that or not.
Jonathan, I think there was an English case recently. I'm making a statement asking you questions, don't worry. I think that there was a recent English case, the Libyan Investment Authority case, where very extensive provisions and directions were put in place to protect the identity and information and evidence given by a witness, including protecting him from the fear of the DOJ and all the rest of it. Yeah. So similar principle. Yeah.
I'm always a little afraid to give the microphone to Keith, but I'm going to give it to him.
Thank you very much. And I was just going to elaborate a little on what Jonathan said. I mean, I wouldn't want to thought as an officer of the English court that I would be critical about the British legal profession or the jurisdiction. But I do believe that the confidentiality club regime has been completely abused, not necessarily in the case in which Jonathan has obliquely referred, but simply because it's become a new toy for litigation lawyers. We now have an industry created of confidentiality clubs, and I can tell you how absurd it is, because in our particular case, not only were the lawyers, so both us and leading and junior counsel, required to sign personal undertakings confirming we would hold the information confidential, but it descended down beyond the paralegals to the secretaries and then to the office staff who would be doing the photocopying in case inadvertently they came across a document. And we've had massive rows and hugely expensive litigation about the use of the confidentiality club. So, Ed, I wouldn't suggest that you transport one of our wonderful customs into US jurisdiction too soon.
Too late. We have it already. We call them joint interest agreements, and they are abused here as well, but less so than what you've just described.
I just wanted to respond to Jonathan's observation that in England we have this problem of the Ramelos decision, which suggests, as you said, Norwich pharmacal disclosure orders, which are critically important in global asset recovery cases, have a real problem when they confront the Evidence Proceedings in Other Jurisdictions Act of 1975, because apparently the judge must have concluded, I haven't read the judgment, but I think he must have concluded that that modern statute somehow impliedly repealed or altered the right at equity or common law to get a disclosure order. Well, in February of this year, Mr. Justice Wallbank, sitting as a High Court judge in the BVI, confronted that decision of, I guess it's Justice Flau in Ramelos in London, and rejected it. He said, look, in the BVI, firstly he considered that the judge constructed the jurisdiction far too narrowly, and he made the point that, BVI courts will not follow this decision as it's of crucial importance in the fight against fraud internationally for the court to grant disclosure orders in aid of foreign proceedings in order to recover assets. That's the whole point, is that people fragment ownership of wealth, location of wealth across national boundaries, and if judges begin to erect barriers to the process of tracing and discovering where this fragmented puzzle of value is located or in situ around the world, then we might as well just give up the ghost and go home. And for some reason, judges in London have a tendency sometimes who went to Oxford and Cambridge to go in big circles analytically and be detached from reality.
Martin, can I just follow on from what you said? I'm pretty comfortable that the Crown dependencies, Jersey, Guernsey, Isle of Man, would follow what your judge has said. It's one of the reasons that I'm fairly comfortable we're going to get disclosure from the Middle Eastern Bank, is the policy of the offshore courts, at least the ones I practice around, to discourage fraud. Once they've got a sniff of fraud, they want to be able to say, we will not tolerate the misuse of offshore structures to hide assets from the victims of fraud or from judgments of friendly courts.
I would say that would be the same position in the Bahamas as well. Definitely in the interest of comedy and combating fraud, courts will not let unnecessary hurdles be put in the way.
So I would be remiss if I didn't thank Bruno De Camargo from my firm, who's helped us put this panel together. Now, the way this works is we have a short break, then all of you come back, because the second half of this is even better, as good as these folks did. The second half.
I disagree.
Even better. So please help me thank these speakers.